There are new concerns about diversity programs in the workplace and hiring after the Supreme Court upended affirmative action in college admissions last week. While the justice's ruling does not legally interfere with diversity in the workplace, experts say the move creates an opening for conservative groups to challenge business policies based on hiring and promoting minority employees. For more on this, let's bring in Noam Scheiber. He is a labor and workplace reporter for the New York Times. Noam, thank you so much for joining us.
Good to be here. Thanks for having me.
So how exactly could diversity in the workplace be threatened in all of this?
So I think there's a sense that even though the Supreme Court decision doesn't directly impact diversity programs in the workplace, that this is likely to prompt a new round of litigation over these policies. A lot of companies expanded their diversity programs in the aftermath of the murder of George Floyd in 2020. And in some cases, they may have gone a bit too far. They may have crossed the legal line. And there's a sense that there could be additional legal scrutiny of that, more cases brought by employees who are passed over for a job or a promotion, and that if it ends up in the Supreme Court, these policies end up in the Supreme Court, then the court has signaled in this recent decision that it could be pretty skeptical of some of these policies.
So what is the argument here by these conservative groups? Why are they arguing against them in terms of thinking that they are illegal?
Yeah, so under the relevant statute here, which is Title VII of the Civil Rights Act of 1964, employers are not supposed to base hiring or promotion decisions on race. And so there is a sense that some of these programs may go a little too far. Say you have an internship that's only available to candidates from certain minority groups, or a leadership training program that's only open to certain candidates from certain groups. That could be illegal under the Civil Rights Act. Now, there are some exceptions under the law, and they're very important. One of the key exceptions is if a company has a program that is specifically in response to a pattern or history of discrimination at that company. So you're an investment bank, and for decades you refuse to hire Black employees to be investment bankers or financial analysts, then is very likely that an affirmative action program that you've set up is illegal. But the further it gets from something that's kind of specifically remedial, specifically in response to a past pattern of discrimination, that becomes more questionable. And I think a lot of groups are now starting to hone in on those things where the connection to something being remedied is a little more tenuous.
And Noam, you had mentioned those corporate DEI programs that gained a lot of traction in the wake of George Floyd's death back in 2020. So why would businesses even be looking to go the opposite direction now?
Yeah, so I think it's really a concern about potential legal liability. And, I think it's less going in the opposite direction than just trying to put your program on the firmest legal ground that you can put it on. Justice Roberts, in his majority opinion in the affirmative action ruling that was just handed down, said that while race per se cannot be a factor in admission decisions, individual candidates can talk about the impact of race on their lives, say overcoming discrimination and how that affected them. And so I think you might see employers start to just kind of shift the rationale for their diversity programs from something that is very race specific to a little broader, a little vaguer. What kind of obstacles have you overcome in your life? And that the court has signaled would be okay. So I think it's less backing away from these programs than trying to find slightly different rationales, putting them on slightly firmer legal footing.
What happens next in all of this? Could this eventually still end up in a different form in front of the Supreme Court?
Yeah, I think there's a decent chance it could. Now, some of these programs, it's sort of cut and dried. There are probably these internship programs or some kind of leadership acceleration program that specifically specifically excluded candidates other than candidates from certain minority groups. Those are probably questionable. We probably don't need another Supreme Court decision on those, but there may be some vaguer, more intermediate situation. Say you have an affirmative action program in your company because there wasn't necessarily a pattern of discrimination at your company, but your industry, say the tech industry, has historically been very difficult for members of certain minority groups to enter. There are some companies who have affirmative action programs that are in response to that historical pattern, that may be kind of a gray area that the court wades into in the future.
Noam Scheiber, thank you very much for joining us.
Thanks for having me. Good to be here.